Yo, I swear it's only up from here. 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 I hold my chest when I drop these. Once upon a smoke unconscious. Go ponder trauma responses. No return to sender to you bones to pick. Devil on his own agenda. Fully loaded when it renders. This that lonely bender on the strip. Feeling solo at the party and the lowies dipped. D totaled the whip, best way it could go. Last know is the Van Wick, he evaded the nose. Don't call a coyote ugly or a pony quick. Do remember, it's all heard, elephants don't forget. I want the do they even make those 40 years. Shorty blowing smoke rings across the lawn, you know the gist. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here.
Oh, I muted my mic. Peace, Oakland. I'm back in the building. Very happy to be back from vacation. And, I think I'm going to start going live a little bit more because it's more relaxed and I don't have to edit anything in post. And so it puts a little bit more pressure on me to do a good job. Forgive the unkemptness. I haven't shaved. I've been in the woods of Wyoming fly fishing and talking to Kings North and Pogue and Leighton Woodhouse and all of these beautiful post-partisan solutionaries talking about the problems of our world. But on Friday of last week, I finally got the news that I've been waiting for. And if I seem excited, it's not because I'm happy about the city potentially going bankrupt over the coal lawsuit. It's more because I told you so. I mean, I hate to be that guy, but so I have a special guest today. I'm going to bring him on in a few minutes. It is Rob Selna. Rob Selna is an Oakland-based attorney. He actually specializes in land use, CEQA, ironically, with the big news of Gavin Newsom signing something. But we're not here to talk about that, although I may ask him about it since I have him here. But with no further ado, also, Rob used to cover government for the San Francisco Chronicle. And the reason that I wanted to call him here today, because if Rob was writing a story, let me get him on here. What's up, Rob?
Morning.
So here's why I wanted to interview you today. If you were writing and preparing a story on the impact of the coal lawsuit, the current federal bankruptcy case in Kentucky, which is related to a subleasee, Insight Terminal Solutions, what I would like to know is what would be your take on a few questions? And since we never get to actually interview the reporters, they always want to interview us, but we never can interview you. Since you're retired, I'm going to interview you today. So give a short introduction on who you are, what you do, so anyone who doesn't know you can get a little more familiar. Take 2 minutes. You got time.
Sure. Thank you. And good morning. Yeah, my name's Rob Selna. I own and manage a law firm in Oakland. It's a land use and real estate law firm where I work with developers as one of the things I do. I've been doing that for a couple decades now. I was a reporter, but that was a long time ago. I was a newspaper reporter covering real estate development and land use. And the last place I worked full time was the San Francisco Chronicle.
That's it?
That's the short story.
Okay, so
I mean, I guess if you want more, in addition to what I do as a practice.
Yeah, you got 2 minutes. Take the time. That's fine.
Oh, okay. I am also an active member and now general counsel of the Oakland Builders Alliance, which is the one organization in Oakland focused solely on representing the development, construction, and real estate industry in the city. So the membership includes developers, builders, contractors, architects, lawyers, property owners in the city of Oakland who are working on real estate and land use issues and advocating at City Hall for policies, including permit expediting and streamlining to get more things built.
And I'm presuming you're frustrated because everyone who deals with that stuff is frustrated in the city of Oakland. But I don't want to get down the rabbit hole because we'll go down that and we won't do the episode we plan on doing. As we got 34 whole people watching and counting. So those of you who are here, good morning, welcome. Let's talk about what you came to see. And I'm putting up I'm going to add something to, oh, it's already up here. Okay. Sorry, Rob, I'm getting used to these settings.
No, it's quite all right. Take your time.
All right, that's better. Okay, we're going to be covering no coal or sellouts, how no coal in Oakland betrayed the city's taxpayers. And for the thumbnail, I chose the recall protests, where all of a sudden, out the blue, when it wasn't anything to do with the recall, there was no coal back in. As a matter of fact, Sheng Tao took money from coal. I can show people that. She went to fundraisers with Phil Tagami during her actual campaign. Barbara Lee took money from coal this last election, even though she signed the pledge, but you'll never hear that from Oakland side or anywhere else. So it seems to me that it's become a political cudgel. Would you agree?
What has become a political cudgel?
No coal in Oakland fight, even when it's not applicable to the current political fight, it seems to be injected in it. And that's why it shows this thumbnail today.
Well, I think it's taken on sort of an outsized identity as a tool by those who want to use it to say, if you're of a particular political persuasion, you're anti-coal, meaning you're more progressive, you're more environmentally conscious, you're more concerned about West Oakland residents, and you're generally, on the side of the quote unquote progressives, a term I don't really like, but is commonly used. And if you are not on that side of the political ledger, you're a coal supporter. And so it's kind of become this dividing line that's been artificially created in order to create, in an effort to categorize and polarize political positions in the city. So you've mentioned the elections. I know certain city council candidates, when they were trying to get elected, were very hesitant to take money from anybody associated with the terminal at the Oakland Army base and the possibility of a facility that would ship coal from there, because they believe that would generally be unpopular to do. And as you know, if you're making a decision to take money from one side or another, and you generally think it's going to be unpopular, it's going to discourage you from doing that. So it has been used, overused, and probably improperly used, and it's kind of lost the real meaning of the subject.
Well, I don't know if it's lost meaning to the voters, Rob, which brings me to the next thing I'm pulling up. This is an article on the Oakland side during the last election, written by Eli Wolf, who emailed me today, ironically. If you check my X account, I don't want to get derailed, but Eli is such a crumb bum sycophant. I can't stand that guy. So anyway, look at this article. Oakland Coal Terminal developers have a favorite candidate for city attorney, has a picture of Judge Bunda, and talks about how they spent $24,000 supporting her bid. These are independent expenditures that Judge Bunda has absolutely no control of. And so here's what they tried to do. Judge Bunda did not sign the pledge. And I'm going to bring up the pledge in a second. She didn't sign the pledge, but neither did Ken Houston. Barbara Lee signed the pledge this year, but she took money from Phil Tagami and accepted it. Lauren Taylor turned it back. You never saw that in the news. So you never heard anything about a favorite when it came to, it seems that when they don't want the non-progressive to win, there's an issue. So I have a statement from Judge Bunda, a quote from her, because I don't know if you know this, but retired Judge Brenda Harbin Forte is 27 years out of the Superior Court Justice. She's served on pretty much every court. She's won statewide awards for mentoring new judges. So much to the fact that if you ever have her as your lawyer, get ready for lots of judges to recuse themselves rather than having to deal with someone who mentored them, right? So just to give you her standing, she swore in Pam Price. She held that Bible and she swore in Pam Price for DA. But she's a judge. She's not going to sign a pledge before she looks at all sides. And when you look at all sides, by the time this was going on, the city of Oakland had already lost the lawsuit. So look at it, right? We lost it. Judge Wise ruled in a 58 or whatever page ruling that there were 12 different points that Oakland violated this contract in the breach of good faith. And I have a video queued up in a second after I read Judge Bender's quote and I ask you another question. So Judge Bender Harbin Forte retired, ran for city attorney. And she ran to clean up Oakland's corruption and the fact that we lose lawsuits all the time. I mean, we lose tens of millions of dollars in lawsuits. Our city attorney's office has been completely hijacked by political operators. But anyway, let me read her quote. Let me read Judge Bender's quote. And she also led the recall against Oakland's Mayor Shin Tile. Just remember that. The historic recall, the first recall of a big city mayor in the history of the United States, and the first recall in Oakland. So this is Judge Bender's quote about the recent lawsuit. During my campaign for city attorney, I was asked to sign the No Coal in Oakland pledge. As a retired judge with over 27 years on the bench, I knew the importance of hearing all sides before acting, especially when taxpayer dollars are at stake. This case was a clear loser from the start. Signing that pledge would have been a betrayal of my oath to uphold justice and the fiduciary responsibility to Oaklanders, so I refused. Unlike some, I don't scribble my name on activist wish lists just to score political points. Ryan Richardson signed the pledge, city attorney, and there needs to be a full investigation into how No Coal in Oakland and their pals hijacked the Oakland City Attorney's office and the city council, squandering tens of millions of taxpayer dollars on doomed lawsuits in the California state and federal court and the Kentucky federal bankruptcy case. Ryan Richardson should resign for knowingly torching taxpayer money to pander for political support. Oaklanders deserve better than this reckless waste. What are your thoughts on Judge Bender's comments?
Well, the judge I highly respect. I think she made those comments in the context of a campaign that has since ended, and Ryan Richardson was elected, but I know she was speaking as a candidate, and so some of the language reflects that. I do not know where the Oakland pledge, the No Coal in Oakland pledge originated. I don't know who.
I can tell you that.
I don't know. Okay, so somebody solicited these signatures, but they weren't based in a legal foundation, and I think that's what Judge Harbin Forte was trying to say. They were the pledge was a political tool. It was a litmus test to try to identify those who were in one political camp versus another. But I don't know that the pledge was ever purported to have had legal or evidentiary support. It was just sort of, are you in favor of coal or not? It was that superficial.
So No Coal in Oakland was started by a West Oakland activist, a highly respected and effective West Oakland activist, who upon learning, so here's the issue here. This is where it gets nuanced. The initial fears before tests and the protectiveness of West Oakland's was an honest endeavor that ended up, like many cult things, going cult-like, like many movements, as the goalposts shift and people become entrenched in their positions. Mm-hmm. And for example, when I point out hypocrisy, if you are indeed hyper-focused on the environmental health of West Oakland, there's no way you could have remained silent for 5 years about that homeless, the number one issue facing our health, which are homeless and encampment fires. There's no way you could ignore that. It's like environmentalists conveniently ignoring, I mean, not all of them, but the more corporate-sponsored, forward-facing environmentalists conveniently ignoring data centers while focusing on fossil fuels, right? Like data centers right now are the most power-hungry entities we've ever even not thought of. It's like crazy how much power these things use. But there's no protest. All of a sudden, it's like, go ahead, build nuclear, do whatever you want. Why? Because the rich people funding this have different agendas. Anyway, let me get back. It's not unrelated, but it is related. So here's what, I'm sorry, my screen is acting all weird. This is what happens when you're live. So I have this
You're
right here.
showing who put the pledge together. Is that right?
Yeah. So I'm going to go to the No Coal in Oakland pledge. So you understand kind of what it is. It started in 2015 and 2016. They signed an open letter to Mayor Schaaf and the city council, co-sponsored by the following groups. Main one being the Sierra Club, and then you have all of these other ones right here. I used to be a member of several of these groups. Here is the letter, which I signed when I ran for city council in 2020, because I didn't know anything about what happened. And it says, Dear Mayor Schaaf and Oakland City Council, we the undersigned organizations, unions, neighborhood associations, businesses, community institutions, and individuals write you today to ask you to keep coal out of Oakland. As you know, Phil Tagami, president of California Capital and Investment Group, and their partner, Terminal Logistical Solutions, are now proposing to transport coal through the bulk terminal export at the former Oakland Army base, despite previous statements that they would keep the terminal coal-free. I don't know if that's accurate, but that's what they're saying. Coal is bad for the climate, the community, and worker health and the environment. Oakland and California have standing policies opposing the export of dirty energy, including explicit opposition to coal export by both the city and the Port of Oakland. In February 2014, Oakland's Port Commission, I'm not going to read this whole thing, but go here. And they have finally, coal dust and particles pose significant threats to Bay Area air and water quality. It breaks apart easily and creates a dust that contains mercury, arsenic, uranium, and hundreds of other toxins. This is what I'm getting at here. Those encampment fires that happen 2+ times a day in Oakland for 3 years in a row now have gotten zero pushback because it's not progressive to fight against the homeless. And so their activism is neatly compartmentalized into things that they can use to get their people into power, and it's conveniently ignored when it's not. Like, for instance, Barbara Lee taking money from coal, even though she signed the pledge. Let me bring it back up. Remember, she signed the pledge. I'm going to bring the pledge back up because I think people need to see this. Sorry about that. One day I will be able to afford someone to do my back-end stuff for me, but not today. And so take action, sign on to this letter. And then they have another open letter to Jonathan Brooks, who's dead now. I think
I mean, my take on the pledge, if that's what you're asking, is that it was a political tool and it had nothing to do with the lawsuit and would not have ever had any impact on the lawsuit, and was an effort to sort of identify who were in one camp versus another politically in Oakland.
Well, I would say that if you sign a pledge saying that you're going to do anything to stop coal, but you already know that the lawsuit is DOA, because Judge Wise ruled 12 different counts, mind you, and I'll have a video queued up about that. 12 different counts, right? Any one of them, which would have been enough for the city of Oakland to lose the lawsuit. In what world do you think you're going to overturn 12 of a judge's bad faith accounts? And so when you sign a pledge after getting that ruling from Judge Wise, what you're saying is you're willing to spend tens of millions of dollars of Oakland's taxpayer money and risk much more, considering we're being sued for $1 billion by a subleasee. And the deliberations start in July. And if you've been following this show, you know that's not going well for us either, right? We could go bankrupt off of this. So when you sign a loyalty pledge to environmentalists, after you swore a pledge to Oaklanders, I think there is an issue with that pledge. And I think it's improper for any elected official to ever sign a pledge like that. And every single elected official who signed that needs to make a public statement right now that they're not going to jeopardize Oakland taxpayer dollars further in this reckless pursuit. Any comments, Rob?
Well, I think if you're, directly involved in managing the lawsuit, there is at least a perception of a conflict if you're taking a position that is a highly political position about that same topic that you're managing the lawsuit for. So I don't think that's a prudent move. I do believe that the city of Oakland had grounds that they believed it could fight the lawsuit on. My position on the lawsuit goes way back to the federal case, in which the federal court said, look, when the city of Oakland signed a contract with the developer, it did not exclude coal as a commodity that could be shipped out of the bulk terminal on the Oakland waterfront, and coal is a commodity that can be shipped in the United States. And so for the city of Oakland to have wanted to remove coal, they would have had to have done it contractually. I happen to be an environmentalist. I am concerned about air quality in West Oakland, and I'm concerned about in the environment in Oakland and the nation and the world. But I also understand that a contract is a contract from the standpoint of a lawyer. And the mistake I believe Oakland made happened many, 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 many years ago. And the failure on the city's part to recognize that, I think, was its greatest fault. And when the city of Oakland lost the federal lawsuit,
What year was that?
It was 3 or 4 years ago, I think. I think in the city attorney's office at that time, I would have had to take a deep breath and swallow hard and say, look, this contract was not done in a way that protected West Oakland from the shipment of coal. If, putting aside whether the coal dust that would have emanated from the covered trains would have decreased or air quality or made it more hazardous in Oakland, putting the environmental argument aside for a moment, and I know there's been a controversy over whether there are genuine environmental effects of transporting covered coal cars. I know it's transported in Richmond. There's a lot of environmental problems in Richmond, but putting that aside, if you're dealing with strictly the contractual issues, which is what the federal court was dealing with, not the political issues, not the pledge of people's loyalty to certain things, but the contracts, that's where the city made the mistake. And it hasn't sort of eaten the humble pie that it probably should have eaten and said, hey, we should have excluded coal from this contract when we were negotiating the contract many, many years ago, if in fact we didn't want it to be transported through Oakland. Because as federal law stands, coal is a commodity that can still be transported
anywhere in America.
Whether you agree with whether it should be or not. But that probably is the more productive place to protest. That is
but Rob, here's the thing: there was a no coal deal, and this brings me to another point of corruption, because that's what we talk about here in Gotham, Oakland. We're here to get to the bottom of Oakland corruption, because I do believe that Oakland, California, is the most corrupt city in the United States, big city that is. And so, the Oakland Size article, actually, I'll pull it up because this is very, very important. The Oakland Side article, let me share my screen. Once again, my apologies for everyone watching.
The suspense,
I try to do it as quick as possible.
The suspense is killing us.
So this came out a couple of days ago late. The story dropped on Friday. You heard it on Gotham Oakland. Friday, Oakland Side didn't tell you the Monday about a 9-year battle that they wrote countless stories about, but somehow they were asleep all weekend. Here's the part that I wanted to Oakland City Council did not.
I'm going to have to put on my glasses to see what you're showing.
Yep, sorry about that.
It's okay. So it goes back longer than I remember. The years are going by quickly, but so the federal case was longer ago than I remembered.
Okay, here's the part. This is the part right here. And I'm going to read it for you if you can't see it.
I can see it now.
A proposed settlement in 2022 would have let Tagami build a marine terminal that wouldn't transport coal. But this idea died after the developer accused city officials of interfering with the labor agreement. Now, let's talk about that. All of this happened in closed session. So how does Oakland side know about it? It is illegal for anyone. It's a Brown Act violation for people to leak these closed sessions. So who leaked the closed session to the Oakland side? Because there's not a single public record that there was any accusation of interfering with a labor agreement, which is vague at that. A developer accused of city officials. So who, and here's what I'm getting at. When Judge Bender ran for city attorney, and she talked to, and I have permission from Judge Bender to say this, and she talked to city attorney members currently, they bragged about leaking the details of this closed settlement to the Sierra Club and No Coal in Oakland to game plan and figure out how to trick the city and still sabotage California partner groups' deal. Now, I'm not telling you to accept that as facts, but let's say that does come out in court one day that happened. What are the impacts, again, on corruption with our city attorney's office working with these organizations? Because where does Oakland side get this information from? There's no public record of anything having an issue with a labor agreement. So why did the no coal thing fail? And I can point back to several interviews with then lobbyist Greg McConnell. I've covered them on my show. So if you're watching, go back and watch the 4 or 5 episodes we have here. But McConnell never said anything about labor issues. It was about money. It was about, hey, we were going to make a lot more money with coal, and the delta needs to be closed. That's his exact quote. There needs to be something to close the delta between what we told our investors we were going to make shipping coal and a different marine terminal idea. And the delta was too far to make the numbers work. And that was the public discussion. Now, in private, yes, in closed session, where only elected officials and city officials were privy to that, who had a legal responsibility not to leak it, there were discussions about a labor agreement because they like to goon you out with CEQA and all that other stuff. You know all about that, right? You know, project labor agreements and things like that and union extortion. And so they were dealing with that, but that's closed session. So how does Oakland side know to report on it so casually? What are your thoughts, Rob? I need your thoughts on it, brother. Let it out, man. Let it out. This is guy from Oakland. Let it out.
Yeah, in this context, it sounds troubling, but I have to say, Seneca, and I don't think you're going to like this answer. Without leaks, no newspaper can do its job. Without leaks, we don't know about the corruption in the Trump administration. Without leaks, we don't know about Watergate. Without leaks, reporters can't do their jobs. It's part of the ecosystem of gathering information, and it works on every side of the political spectrum. And so I am categorically not opposed to leaks.
What a heterodox answer. And I get leaks all the time. I agree with you. But it doesn't mean that when these leaks come at a financial consequence to the city of Oakland and the potential tens or hundreds of millions of dollars, there should be no accountability for it.
Well, when you say there should be no accountability, what accountability have you requested or demanded?
Ryan Richards should resign immediately. Barbara Parker there should be a criminal investigation and a 4 grand jury investigation and a 4 correspondence audit and scorched earth for the last 9 years about how our legal department has been working with No Coal in Oakland and the Sierra Club. That's what I want. You know why? Because we're going to find out anyway in July with this bankruptcy case because they requested this information. And Oakland has been refusing to give it to the federal bankruptcy judge who basically told them, I'm just going to rule without it.
Well,
right. So I don't want to catch you up on that, but it's very serious.
Yeah, I was just going to say that, from my standpoint, there's 2 things you're talking about here. One is corruption, and you know a lot more about it, purported corruption in this case than I do. The other is the legal process, and I know a lot more about that than I do about, anything you're describing with respect to corruption. And if you just isolate the legal matters and the legal issues, in these cases, I think you can form a fairly critical opinion of what the city attorney's office has done. Okay, and I could just stop there because I don't know enough about the other issues you're describing or don't have any evidence to really answer your questions. All I can do is go back to, as I say, go back to that federal case, which I understood, I think, pretty well, and then look at Judge Wise's ruling, which was on different issues and was decided differently. But as you say, it was a thorough opinion. Judge Wise's opinion was thorough. It was multifaceted. It provided a number of reasons, and the city decided to appeal that anyway, probably with a pretty low likelihood of success. Now, I've taken cases to the first appellate district, the very district that the city took this case, and everybody's chances are low of prevailing there. It's just, you already have a Superior Court decision. You already have a complete ruling. The appellate court on a certain level is going to give some deference to that Superior Court ruling. And so it's always a bit of a, I don't want to say a Hail Mary, but your chances.
Let me ask you a question though. Who did you throw that Hail Mary on behalf of? A client who pays you or taxpayers?
Well, and I'm not saying it was a Hail Mary. It's always, it's not quite a Hail Mary, but your chances are not typically great.
I want you to watch this video because I got it queued up for you because you bring up a good point. There's a difference between the activist side and exactly what's in the court. And I'm pretty ignorant. I'm not a lawyer. That's why I have Judge Brenda as a guest often to filter these things to her and her experience. But let's everybody watch for a second an old episode of Gotham Oakland. I'm going to play about just a few minutes of the judges talking. So if you haven't seen this yet, Rob, you can get kind of where I'm coming from.
Jump ahead to your bad faith. I don't know if you're going to argue the bad faith case of this or not, but and I know you contend that there's no bad faith, and you make similar arguments, I guess. But how is it? Maybe I shouldn't ask how is it, but the judge found at least and find there's at least 12 mentions in her statement of decision of bad faith or breach of the covenant of good faith and fair dealing.
Yikes, that didn't sound too good. Sorry about that. Let me go to the case. Sorry, Rob. Okay. You don't want to hear me yammering on. And I've already covered this stuff here. Okay. Oh, man. One day I can, a matter of fact, this was a good moment to say, check that Venmo down there and like, comment, subscribe, or whatever you can do watching live. And if you want me to have an assistant and have a little small budget to do these things, a little bit goes a long way. So you can understand exactly what's happening.
Contract and agreed to those deadlines. Article 6, Section 6.2.1 is where you will find the steps that OBOT agreed to move this through the process. And
Ms. Leonard, you said that OBOT knew that at the time that it entered the contract that Oakland was considering something to do with regulating coal. What are you referring to and where is that in the record?
So that is, I'm referring to, there was already a September 2015 hearing in which the city of Oakland started the legislative process with respect to coal. Everyone knew that there was brewing a pretty serious dispute over the city's ability to legislate with.
That's the federal lawsuit you were referring to, correct, Rob?
I think it predates that. I think she's, I may be wrong, but I think that the attorney speaking there is talking about potential legislation that was floated before the contract was signed. I don't know. With
respect to coal. This deal was done because the parties agreed to set that to the side and move forward anyway.
How do you lie?
The development agreement was earlier than 2015. So how does that play into this argument? Okay. That is, weren't they already basically committed, or could they have, how did that work?
Article 5 specifically says that nothing the city can do in its legislative or regulatory capacity would interfere with OBOT's deadlines. OBOT agreed to all of that. That's the balance of risk, responsibility, and reward.
Listening to you and your eloquence and your emotion, how is it that a judge listening to all this for weeks writes a 95-page statement of decision rejecting your position basically every step of the way? I mean, are you going to get to what Judge Wise found and decided, or are you just going to talk about reward and the size of the lease?
So, of course, Your Honor, of course. So what Judge Wise...
Let me take a second here to pause it.
Yeah.
What are your thoughts on that? Because it gets a lot worse.
Well, let me just clarify my statement. What the judges made clear was that the city already had a development agreement when it started talking about prohibiting coal being transported through Oakland. And that's really what I've been trying to come back to this entire time, is this contractual obligation that the city had that predated its stated desire to prohibit coal from being transported. And, you know, a contract is a contract, and what a party that is a signatory to a contract to maintain credibility, to maintain reputation, to maintain the rule of law has to comport with the provisions of the contracts that it signs. Again, that's kind of, there's a lot of politics here. There's a lot of innuendo and insinuation and all kinds of other things, but you know, sort of, and I know that the Superior Court case was on different issues or additional issues. But when I've thought about this case over the years, I have come back to, well, the city of Oakland signed a contract, and whether you're an environmentalist, whether you're a progressive, whether you're a traditional liberal, whether you're a conservative, a contract is a contract. And at a certain point, you have to own up to that.
Who signed the contract? Who led that?
The city of Oakland.
I know, but who was the person who was like, isn't it on the mayor? Doesn't the ultimate responsibility fall with former Mayor Libby Schaaf?
You know, it was probably a combination of agencies that were signatories to it.
Wouldn't the city attorney's office have to be a part of the 60+ page contract? I think it was 65 pages.
Well, the city attorney's office reviewed it and drafted it. Yeah, of course. Participated.
So they were well aware that the city, in serving as both the leasee and the regulatory agent, had good faith responsibilities. Would it not be like, what I'm getting at is this, and forgive I'm not a C student, I went to Cornell, but talk to me like the normal Oaklander who's trying to wrap.
I think I am, yeah. I'm trying to.
No, it's hard. That's why you're a really smart guy. You're good at breaking stuff down. But I'm still having trouble grasping, not from your explanation. Your explanations are good. I think you've shown that you have a good grasp and balance of our sides. So I'm more of asking you now questions not to challenge what you're saying, but just to make sense of it.
Sure.
We've known for years that we've signed a contract. A contract is a contract. And so why would you sign these loyalty pledges election after election, knowing it's going to require you to violate the contract? Because that's what it feels like to me. The city attorney's office, Ryan Richardson signed the pledge. In year 8, in year 9, right?
Well,
or whatever.
All I can say is this: the city attorney's position is an elected position. In some cities, it is an appointed position. And the reason it is an appointed position in some cities is in an effort to take the campaigning and politics out of it, because there is perceived potential conflicts for a city attorney to be a politician. That's the system we have in Oakland. It has advantages and disadvantages, because if it's an elected city attorney, as it is in Oakland, that person has more independence on some level. And while the city council and the mayor are the client of the city attorney, the Oakland charter includes a provision that the public at large is a client of the city attorney of Oakland. And so the city attorney here has more independence in some ways than they would if they were to be appointed by the mayor. But it creates this potential for politics being infused into the decisions that the city attorney's office makes. That's inherent. That's not unique to Oakland. That's inherent in that structure. And so my generic answer to you, without knowing many of the details that you know or many of the things you've heard, is that's part and parcel of an elected city attorney position. Now, each city attorney who's elected has to decide how they're going to manage that, how they're going to manage the politics, and how they're going to manage whether the politics interfere or become involved in the decisions that the office makes. It's sound advice for the city attorney to the extent possible, keep politics out of the decisions the city makes with legal decisions.
Well,
and
in the words of Andy Duong, Rob, money buys everything. Okay? And it's obviously bought some people, because I got some to share with you. So, we're looking at some donations here. I want to turn your attention to the Anthony B. Martinelli and Serafina B. Martinelli gave the max. This was on, sorry, this is this one. Okay, so Maria B., you know who that is?
Yeah, I do. And in fact, her family is childhood family friends of mine, so I don't really.
Oh, great! I love it when it gets personal in Gotham, Oakland.
Yeah,
okay.
I wouldn't really want to comment on anything Maria B said.
Hey, you don't have to comment. I'll just talk to the audience instead. So Maria B is the chief city attorney to Ryan Richardson, and then all these things are common. I'll talk about this later, but just to give you some sense of some issues here. And then she gives the max to Ryan before her children give the max to Ryan, and then she gets the job after. And she's also been a staunch supporter of the no coal in Oakland. Now, as an environmentalist myself, again, if we were truly environmentalists, why is there not a word being said about the environmental impact of all these RVs leaking sewage into our drains, oil in our drains? We have 72-hour RV laws. We've averaged 3 vehicle fires per day in Oakland encampments, or 3 encampment fires per day for 3+ years now. 70% of the encampments are in West Oakland. Not a peep has been said about any of this. So I call bullshit on so-called environmentalists if they're not really focusing on what the impact is, right? Me as an activist, we organize around the issues that are most pressing. And these issues are very pressing, and they don't seem to care about them. And it's been brought to their attention many times in juxtaposition to this seemingly hyper-focus on this coal fight. I add you one more thing. There have been studies, I can say this now, I couldn't say it 2 weeks ago, but I can say it now. There have been studies that prove that the coal dust doesn't play out like they say. It doesn't have the environmental impact nearly what they say.
Well, that was part of Judge Wise's ruling. So
you do know a little bit about it then?
I do know a little bit about it, yeah. Yeah.
Okay,
but
well, that's some granular detail there.
But I wouldn't. So, Seneca, this is not the first time environmental issues have been used in politics, right? It's happening every minute of every day in Washington.
Rob, here's this has the potential to bankrupt the city of Oakland. Let me go through the numbers. Okay, all right.
Don't get me wrong. You keep going back to the RV fires, though, and how nobody's talking about that. Unfortunately, we live in an age when political sort of efforts, political movements, political persuasions pick and choose pieces of issues that they want to use to persuade the public. Unfortunately, the environment writ large and in small instances has become one of those tools. It shouldn't be. We should all want clean air, water, soil, and quality of a healthy, clean, vibrant environment. But
you know what? I wasn't going to talk about this, Rob. Sorry to interrupt you. You're going to have to talk a little bit more, so it'll be worth the interruption.
How much longer are we going?
I mean, I have like another 30 minutes, but you can leave anytime you want. But you got to answer this question first.
Okay, I got to go after this.
Okay, I know you got to get to work. You know, you have like a real day job. You're a lawyer and stuff. But by the way, I really appreciate this banter. I think that what you're showing me is that I really hope you may consider joining some commission or maybe even running for office, because you have a very level-headed, measured approach to this. Even though you are an environmentalist, I like how your thought process is working, because I'm after you right now, and you're resisting in a good way. You're helping guide me to be more.
Hey, a lively debate is critical to a healthy democracy, right? People got to be able to talk. They can't just go to their corners and avoid conversation. So I'm happy to push back anytime.
And so I want to bring up something real quick. This is my last question, and it's asymmetrically related to okay. You wrote an article in the SF Chronicle that sheds light on misuse of the California Environmental Quality Act, better known as CEQA, by local construction and trade unions. The 2022 piece published in the Chronicle discusses how trades exploit CEQA to try to obtain no-bid contracts. In doing so, they drive up housing costs. Check out the full article, blah, blah, blah. For your last, my screen share audio.
That was probably an opinion piece I wrote long after I left the Chronicle.
So this is pretty much an extension of what you were just saying, right? So you're talking about how environmental causes are hijacked. Give us some context of what CEQA, in your opinion, was meant to do and how it's been misused.
Okay.
So whatever time you want for your last one.
Yeah, there was just the news item here is there was a big CEQA bill signed today by Governor Newsom that exempts infill housing development, meaning housing development in already developed areas, typically urban areas. It frees housing development in those areas from review under the California Environmental Quality Act, meaning it frees them from environmental review entirely. Part of the reason this bill came to be was that the vast majority of appeals of housing projects by trade unions, meaning electrical, plumbing, the construction trades, was urban infill housing. And what the construction trades were using to appeal these projects was the California Environmental Quality Act. And the reason this tool was available to construction trades to use to appeal, when I say appeal, I mean the approval of housing projects at planning commissions and city councils, is that CEQA was intended to be a public process. And CEQA was intended to bring in the public to serve as an enforcement and expert opinion about the environment in which the public was existing, living, working, raising their families. And so CEQA invited public participation in order to enforce the Environmental Quality Act. That has been misused for decades now by trade unions that are seeking to, I'm going to use the word extort because I think it's that plain and simple, from developers.
Oh, I'm muted. That's the strongest word you've used today. Thank you. Thank you for coming hard with that one. All right.
Bottom line is, California has prevailing wage laws. California has health and safety standards. Many cities have prevailing wage laws, but trade unions have long advocated for their own set of quote unquote labor standards. That doesn't mean that the labor being done by non-union workers is unsafe, unhealthy, generally shoddy work or anything like that. But that's what the trades argue. They have a self-interest in maintaining their wages. They have a self-interest in maintaining their healthcare. They have a self-interest in maintaining their demands for their members, right? It doesn't mean that any non-union laborers are going to do poor work, are going to be injured, are going to be harmed. But that's the dynamic that the trade unions set up in order to have their demands met. And they take those demands historically, let me say historically, they have taken those demands to developers and said, hey, you know, we're happy to work on this project. We'd really like you to sign an agreement using our labor and our standards. And we, you know, otherwise we don't have a lot of interest in this project. We will note to you that this project may have some environmental issues that you may not have thought about. And so we may be forced to raise.
It may just happen to have some environmental issues.
We may. I'm trying to make this conversational. I'm trying to give you an anecdote.
No, I get it, because look at my screen. You see what I'm sharing right now.
That has played out for decades, and what it's done is it's really suppressed, inhibited, reduced the amount of housing that has been built. Now, the trade unions will argue, well, so few of these cases end up in court. This is just an overblown claim by housing developers who are greedy. We're not stopping these projects. We never take them to court. Well, that is a misdirection play by the unions, because what happens is they oppose the projects at the planning commission. They appeal the projects to the city council or the board of supervisors. And in many instances, those city council members and supervisors are elected in some part by these trade unions. And, you know, the East Bay, Oakland in particular, is a very strong union town, right? So, you know, if you're going to get elected, if you're going to get elected in Oakland, it's very hard not to take union money. There's not enough other money floating around out there, frankly. So it has long been a problem in Oakland. It's long been a problem in the East Bay. I have had clients who've been subjected to this form of extortion, and it's wrong because it doesn't serve environmental purposes, and it doesn't serve housing development purposes. It really just serves the interests and the needs of a very small special interest group of people, many of whom don't live in Oakland. So I'm really happy with this bill that Newsom passed. It is taking the vast majority of legislation that Buffy Wicks, an assembly member who represents Oakland and Piedmont and I think part of Berkeley, came forward with very courageously, because it was not popular among people who elect her as well, or help elect her, which is the trade unions in Sacramento. So I'll leave you with that. I'll also leave you with the plug for my environmental organization. As I mentioned to you, I'm an quote unquote environmentalist. I started a nonprofit organization 11 years ago to build gardens in abandoned public spaces and to plant trees in Oakland. It's called Sidewalk Trees and Gardens. We've planted 16 trees on Campbell Street in Oakland, West Oakland. In May, we have a plan to try to plant more than 100 in West Oakland in the fall. So you asked me questions about the environment in West Oakland and air quality. I'm very much a supporter of doing our best to clean the air in West Oakland. Yeah, this is our organization's webpage here. So please, if anybody who's listening or watching, take a look at our organization, take a look at our website and see what we've been doing. We got big plans for the fall.
Thank you, Rob. I'm sorry to do this for you, but just really one question. Are you familiar with this housing development that never happened in West Oakland?
Yeah, I wrote an opinion piece about it.
And does this have to do with the what you just spoke about?
It has precisely to do with what I just spoke about. Yeah.
I thought so. And you know what sits there now instead of this beautiful, dense housing that would have helped alleviate our housing issue?
Yeah.
One of the largest encampments in the city.
Yeah.
I'm going to call it Fife Land. Maybe it needs a name, because since Carol Fife is responsible for blocking this project here. That's my words, not Rob Selna's. Don't come to him for that. You know how crazy those people get. Okay, Rob, I really appreciate you making the time today to stop by. And thank you for your sage wisdom and your institutional knowledge on a lot of things that you were able to share with us today. Peace, brother. I'll see you soon.
Peace. Thank you. Appreciate it.
All right. I don't think I got to get on with my day. And I'll probably be doing multiple episodes about this no coal in Oakland issue. But let me leave some closing thoughts. There needs to be some accountability. The federal bankruptcy case in Kentucky, now that this case is settled, it's extremely likely we're going to lose that case because the bankruptcy case hinges on the fact that the city of Oakland violated a contract which led to the subleasee Insight Terminal Solutions going bankrupt when they had a prior valuation of over $1 billion. Now, would they get $1 billion in this bankruptcy case? I don't think so, most likely not. But it could be anywhere between $1 and $1 billion. And my estimate is going to be close to around $100 million or so on the lower end. When you combine that with this breakdown, probably $10 million easy, City of Oakland legal fees, another $10 million roughly owed to OBOT, that's 20. The lease was $1 million a year for 9 years so far. That's another 9. That's 29. Let's just round up to 30. The taxes that they would have paid on that, the subleasing taxes they would have paid on that, the employee taxes that they would have paid from those subleases, and then the income taxes people who lived in Oakland would have paid by having good jobs, and the city of Oakland having hundreds more jobs for our most valuable asset, the Port of Oakland, which is now sitting there not making us nearly as much money as it could be making us. All of that was in jeopardy because people decided to put their own environmentalist causes before representing the city of Oakland, who, as Rob Selna admitted, or not admitted, but informed, we signed that lease. Libby Schaff and Barbara Parker, who was the city attorney at that time, all signed that lease, 65 pages, negotiated over months. And then immediately after signing it, went to war to block, using their regulatory power to block the deal. And then after losing the federal lawsuit, losing the first lawsuit, still will continue to push our money into the appeals. And I have one more thing. That bankruptcy case in Kentucky was elective. Why did the city of Oakland hire a lawyer across the country to butt their heads into a bankruptcy case that had zero to do with Oakland taxpayers? Spite. Loyalty to No Oakland and the Sierra Club, environmentalist causes over the city of Oakland. And for that, I agree with retired Judge Brenda Harbin Forte that Ryan Richardson should be recalled. I mean, we don't need to recall him if he resigns, but he should resign today. Ryan Richardson, please resign. It's only going to get worse when we lose the bankruptcy case. When the city of Oakland eventually goes bankrupt because partially your action, I'll be right here waiting. Y'all know what time it is. Peace, love y'all. Have a great day.